The proceeding will start shortly. 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 The proceeding will start shortly.
May I welcome you, Mr. Alexander and Ms. Florence, to the committee, and thank you very much for your time and giving evidence at a particularly important moment in the progress on this very issue. I've had many friends in the patent bar, Mr. Hamilton, Mr. Alexander, and I very much welcome your generosity in giving us your time. Now, once members of the public are here, I have to say a transcript will be taken and made public, and witnesses will have a chance to review this before it is published. The session will be webcast live and subsequently made available to view via the parliamentary website, and any member here should declare an interest. But thank you very much for coming again. I would take the first question, which is really to set the ball rolling. It would be very helpful for the record to have the relationship between the European Patent Convention, European law, and the Unified Patent Court explained, and I would be very grateful if you would do so. And we have the background, the only document we have as regards the view taken by HMG is a piece in the Law Society's Gazette, which we will explore further, which apparently deals a death blow to the UK's role in the Euro Patent Court. So it's particularly important that we explore this issue and have. And could I ask you all to speak up, because the acoustics in this room are particularly bad. So if I ask you to speak up, it's not a criticism, it's merely because I want to hear better what you have to say. Who's to speak first?
Okay, thank you, Lord Morris, and thank you for the opportunity for us to speak to you today. I'm happy to take the first question, or at least the first part of the first question. My background is that I'm a patent attorney. I'm a UK qualified and European qualified patent attorney, and I've practiced for about 40 years. And in fact, I started practicing at about the time the European Patent Convention came into force. So let's start with the European Patent Convention. the first thing I want to stress is that this is not EU law. It is an international agreement, and the EPO, the European Patent Office, which administers the European Patent Convention, is not an EU body. They are quite separate, and that is a very, very important point to note. So the European Patent Convention, EPC, is an international agreement which dates actually from 1973, but came into force in 1978. It has grown over the years and now encompasses some 38 European countries, including, and that includes all the EU member states, but also a significant number, now 11 including the UK, of non-EU states. So it is pan-European, it's not EU. The UK was one of the original members of this convention, and a very important and influential member it has been and still continues to be. In fact, the European Patent Convention is a fantastic model of European cooperation in the IP area, and it's been so successful that there are now a number of countries which, although they are not full members of the convention, they're called extension states, and some of those are outside Europe, for example, Cambodia, and they have agreed to accept a patent granted by the European Patent Office in their own country. So it's a really successful model. And what does it do, the European Patent Convention? It enables an applicant, a company or a person, to file a single patent application, which is then processed centrally by the European Patent Office. It's examined and processed up until grant. So that's just a single application for all these countries. So it's quite cost effective and it's very time effective, rather than having to file at all the individual national patent offices, and I remember doing that when I first started training. But when the patent is granted, it then does not remain as a single right. It splits into a bundle of national patents. So if you have asked for patents, if you filed your application, you can designate, as I say, up to 38 countries. You will then have the potential to have the patent in each of those 38 countries. At that point, you have the choice whether to proceed in every country. You have to pay fees to each national patent office, and in some cases you have to get translations. So depending upon the importance of your invention, you may decide to carry on in all 38 countries, which is again quite costly, or you may decide just to carry on in a subset of those countries, perhaps the ones that are most relevant for your technical area. Crucially, because those patents are now national rights, you have to enforce them separately in the national courts of each country. So, does that...
Yeah, thank you very much.
Is that clear? As I say, the UK has been a very influential member of the European Patent Office, and European patent attorneys. So in the UK, as I say, most patent attorneys in the UK are qualified both to act before the UK Patent Office and the European Patent Office. And UK patent attorneys carry out a lot of work, a substantial amount of work at the European Patent Office. It is by far the most attractive route. We have a wonderful patent office in the UK IPO, and they do a great job, but most applicants prefer to go via this centralised route. And UK patent attorneys represent clients not only from within the UK before the European Patent Office, but we bring in work from around the world, the US, from the Far East. We are regarded, we're very highly regarded as European patent attorneys, so it's a very important part of our work. And in fact, I've seen a statistic that says although UK patent attorneys represent a fifth of all qualified European patent attorneys around Europe. We actually do a third of the work, so we definitely punch above our weight in terms of working at the European Patent Office.
Thank you very much. Mr. Clark.
Should I
Alexander?
add very briefly? First of all, thank you very much for inviting us to this committee, Mr. Chairman and members. It's a pleasure to be here again. I'm a practicing barrister and deputy judge, and I'm also the chairman of the Intellectual Property Bar Association. And perhaps I could just add a few words by way of segue as well to the next question about the relationship between the European Patent Convention, EU law, and the proposed Unified Patent Court. A few words of history, just for those who are not very familiar with the patent system. The original idea of the patent system was that individual nation states would grant individual national patents which gave monopolies within those national territories. And in this area, as in many others, there has been a gradual process of internationalization of rights. Partly that has followed the internationalization of science, technology, and creativity, and partly it has been a response to the internationalization of trade. And the European Patent Convention, which, as has been said, is not an EU convention, is part of that process. It's an initial part, in that what it does is it says there will be a single grant process for a patent for the countries that are part of the convention, so that you don't have to apply to individual national patent offices for a patent to cover those countries. You apply once, it's examined once by very highly technically qualified people in the EPO. There is a period of opposition, relatively short time period of opposition, so that if the patent is essentially clearly invalid, the idea was that one could get rid of it rapidly, an almost administrative or quasi-administrative procedure. But then each of the patents took effect as national patents. Now, the problem with that, and one of the impetuses for the UPC originally, was then you had to enforce the national patents in each individual country. So if you wanted to enforce your patent in France, you had to go to French courts, in the UK, the British courts, and so forth. So the idea of the Unified Patent Court was to say, well, let's take this bundle of European rights, and create a court which will enable you to enforce them in a single venue, basically. It's somewhat more complicated than that, because the way that the court is proposed to be set up provides for multiple places where that can take place. It's a little bit like the United States federal system, where you can enforce federal rights in district courts, and they're effective throughout the territory of the United States. In addition, the EU wanted to make good on something that has been a kind of dream of the EU for quite a long time, which was to create effectively a community patent, a unitary patent that would be effective as a single right, unitary right, throughout the EU. Now, there is actually already a model for that in terms of EU rights, namely EU trademarks. You can apply centrally for an EU trademark, you can enforce your EU trademark in the court, the High Court, sitting as a community trademark court, or rather you could before the 31st of January. And you could have rights effective throughout the community. So one of the ideas was, let's try and do that for patents. Hence, a court that would take both the bundle of rights and the new unitary patent and enable someone to enforce, or, just as importantly, to knock out an invalid patent for the whole of the territory in question. And I emphasize knocking out patents because it's quite easy to think of intellectual property rights as being things that are necessarily valid and so forth. As much work is done in getting rid of what might be called legal litter, namely the invalid rights that people have improperly obtained because they're not novel or not obvious or infringe some other provision of the relevant law, as are cases in relation to enforcement of rights. So the idea of the Unified Patent Court was to provide for both, well, still is to provide for both of those opportunities, and to come on perhaps to preempt question 2, the reason why it was necessary to pass EU legislation that is referred to in that question was in order to create the unitary patent, which was one of the 2 sets of rights that was to be enforced in the unified patent court. Now, the final point on that, on EU law, is that obviously within the EU law takes precedence. We'll come on to discuss the extent to which it's important at all in the context of patents, because one of the issues that has bedeviled this debate is a sense that the formal supremacy of EU law is not actually reflected in this area in its importance in decision-making, which is why red lines in relation to this are questionable. We can come on to debate that. But formally speaking, EU law governs all of the legal relations at that level. But it is equally important to understand that for patent law, save for a few areas that we can come on to, EU law really has nothing to say. The law of obviousness, the law of novelty, the law of infringement, these are the fundamental things in patent law. Those are not creatures of EU law. Those are harmonized by the EPC, and the Court of Justice and EU law really would have nothing to do with those fundamental areas. I don't know whether that's helpful.
Very helpful.
And
we'll move on.
If I may just add one further point, I may not have made it clear when I was talking about the European Patent Convention and the European Patent Office, but no cases that are brought before the European Patent Office can be referred to the CJEU. There is no nexus, there's no mechanism, it's totally independent, and so there's no means of referring cases from the European Patent Office to the CJEU.
Thank you very much.
That's very important.
I think it's been said, Chairman. The question about why the agreement was pursued outside the EU, but the EU legislation was necessary. I think Mr. Alexander's covered that.
There is a related question, which is actually which is relevant to what we may come on to, which is why the UPC agreement makes EU law the supreme law. So it's the other way round. And that actually has some historical reasons which are relevant for the committee's deliberation. Originally, the professions and industry wanted something that would cover not just EU member states, but actually all of the EPC member states, that everyone could participate, including the Swiss and other important territories.
Well,
for all sorts of political reasons, that was not possible. But the EU then said, actually, if you want to do it yourselves, you have to make EU law supreme.
Question 3, Baroness Cody. We've covered some of the ground already, but perhaps we can explore it further.
The formal relationship between the Unified Patent Court and the Court of Justice in the EU, how do we see that now?
The Unified Patent Court, although it is a court that's under an international agreement, nevertheless, as Daniel has said, will apply EU law, but only to a very small aspects of the patent cases that are before it. So the UPC is obliged, as the national courts are now, to refer any issue, any question of EU law that arises during a patent case to the CJEU. However, questions of EU law very rarely arise in patent cases. There is very little EU law applicable. One area where it does arise is in relation to supplementary protection certificates, which are a form of patent term extension, and if you wish, we can say a little bit more about that. But in the great scheme of things, for example, European patent attorneys who practice day in, day out in the area of European patent law very rarely have any cause to refer to EU law or to the CJEU.
Thank you.
Lord Anderson of Ipswich.
Thank you very much for that answer. I should declare an interest as a colleague and a friend of Mr. Alexander, but my question is to Ms. Florence. In view of what you've just said, is it going to be the case also in the future, do you anticipate, that questions coming up before the UPC will not involve questions of EU law, or is this a field where the EU jurisdiction is likely to encroach in the future? We've already got, obviously, the Unitary Patent. Is this an area where EU law is going to take over, or is it going to remain very much distinct from that?
I think the substantive patent law will always remain distinct from EU law, because substantive patent law has been around for a long time. It's very largely harmonised, not only within Europe but around the world. So there may be where patent law may intersect with EU law could be in relation to what types of invention are patentable, and who knows what will arise in the future. And there were at one time some questions in relating to inventions related to stem cells, so biotechnology inventions, which fell within the EU Biotech Directive. So there was a bit of an intersection there. But for, by and large, most inventions, normal run-of-the-mill inventions, even normal pharmaceutical inventions that don't involve some of the biological aspects, would just fall under your everyday patent law, and I can't really see how the EU law would encroach upon that.
Should I add something to that? I'm sorry. Just briefly on that. There are, broadly speaking, 4 areas where EU law has an impact in this domain, but they are very limited areas, and EU law has a limited impact. One has been mentioned, which are supplementary protection certificates, and the reason that EU law has an impact is that supplementary protection certificates are themselves a creation of EU law for complex legal reasons we need not go into now. And so the Court of Justice has the right to say, well, these conditions are fulfilled for essentially an extension of term of protection for certain pharmaceutical products. But that's a very narrow category of inventions. It's not unimportant. It's very important for the pharmaceutical industry, but it's a narrow category. Second area is remedies under the Enforcement Directive. But here again, the EU, the Court of Justice, hasn't had a great deal to say so far. And the thing about the Enforcement Directive is that, if anything, what that did was say to the rest of Europe that it ought to be doing the same things that the UK does in any event. The third area is, as has been said, some exclusions from patentability, which are again harmonised at European level. So far, really the only impact has been very small in a specific area of stem cells, or processes for stem cell research derived from human embryos, because of the restrictions on patenting, in inverted commas, life, which were agreed in Europe. And the final area is one which is general areas of law, competition law and so forth, insofar as they may affect patent cases. But for what might be called the common or garden patent case, cases of mechanical inventions, cases of probably most small and medium-sized enterprises in this country, EU law really would have no material impact, and the Court of Justice would have no material impact.
And of course, it is only those aspects of EU law that can be referred, and not the whole patent case as such.
Well, we'll move now to the key question, question 4. I've already expressed to colleagues my surprise that the news of the government's attitude has only been made through a piece in the Law Society Gazette. We will explore that further. But perhaps, Lord Gold, can you ask the...
My question is, what is your assessment of this decision by the government that it's not seeking involvement in the Unified Patent Court in future? And the reason seemed to be, as said in the Law Society Gazette, that because the court that applies EU law, bound by the CJEU, is inconsistent with our aims of becoming an independent, self-governing nation. When answering, I am curious to have your views as to what will happen next.
Well, if I may start with that. Obviously, the announcement was extremely disappointing to the whole of our profession and to businesses. Since the referendum, we've had many meetings with government to consider what the impact of Brexit on intellectual property in the UK might be, and the UPC obviously played a very large part in that. We understood that there were red lines in relation to the CJEU, clearly. That had been said many times by the government. However, because the Unified Patent Court is actually an international court, we understood that there were concerns about the CJEU having an influence over UK courts, but we thought there's a distinction here because the UPC is an international court and people can choose to use it. If people don't, there are alternatives. People can still file patent applications nationally in the UK and deal only with the national courts. So that option remains. So we felt there was a distinction, and we had hoped, and there had been noises, that the government might make some exceptions to the red lines in relation to technical areas such as this and some other areas. Certainly, the UK Patent Office, the UK IPO, and successive IP ministers have all been very supportive. They've voiced supportive to our views on continuing to be a member of the UPC. We've had some very constructive meetings with recent IP ministers. And so it was really a blow when those hopes were not able to come to fruition.
It is a death blow.
Well, I like to say never. We certainly hope that even if the UK cannot join or be a member of the UPC for now, that the door is left open for the possibility that non-EU member states, not just the UK but other non-EU member states, could at some point in the future be part of that system.
Mr. Alexander, would you like to add?
Yes, I share those views. I think it's a regrettable decision, and I'm afraid to say I think the reason given for it is a unjustified one. And it's particularly unjustified in this area. The Court of Justice, as we have indicated, first of all, plays a very limited role in this area. Secondly, the role that it plays is an indirect role, in that it's not directly influencing UK position. It has a role in stating what the principles are in certain limited areas in relation to a common court. And thirdly, one has to remember that the Court of Justice is not this kind of directive imperial body telling the UK what to do, and particularly not in this area. There are references made to the Court of Justice to set out general principles of law. It is then left to the courts of the member states to implement those decisions. It is one of the most, in a sense, respectful of lower courts' appeal processes. In fact, even to regard it as an appeal process is not even quite correct. So you have a combination of light touch judicial regulation, indirect, in limited areas. And to say that that is incompatible with the United Kingdom becoming an independent, self-governing nation, I have to say I just don't get that argument. What it is rejecting a practical means of cooperation. The thing about patent lawyers and people who deal with patents, they tend to have a kind of engineering mindset. They're quite sort of techie and quite practical. And part of the reason for getting together is say, well, look, if we can do this all in one court, let's have a one-stop solution. Let's make this a little bit simpler and more practical. I'm not really interested very much in kind of what might be called jurisprudential ideology. To have a kind of ideological objection to some tiny involvement in specified areas which are advantageous to the UK. Let me just give you an example from a recent case, most recent case on supplementary protection certificates. High Court should declare an interest to an extent that I appeared in it. High Court said, this is the answer, but I'm not completely sure, let's refer it to the Court of Justice. Court of Justice said, yes, your reasoning is perhaps slightly, we put it in slightly different ways, but basically you're right, that's the answer. It comes back to the High Court that says, okay, that's the answer. The Court of Appeal says, that's the answer. Okay? The effect of the reference to the Court of Justice was not the Court of Justice dominating the UK. The effect was, in fact, the opposite. It was the UK suggesting to the Court of Justice, this is the way you should answer the question. The Court of Justice answering the question for the whole of Europe. In one strange way, you could say that, in a way, the High Court was using the Court of Justice as an instrument to impose UK approaches on the rest of Europe rather than the opposite. So the idea that you have this court that's dominating, and that's a reason for not doing practical cooperation, seems to me fundamentally misconceived.
Thank you very much. I've got 4 colleagues who want to come in on this very important issue. It goes to the heart of the matter. Lord Anderson of Swansea first, but then there's Hamway, Lord Anderson of Ipswich, and Lord Gold would like to come back in that order, please.
To an outsider, it appears that last helpful answer by Mr. Alexander suggests that the mantra of sovereignty dominates, and that whatever damage may or may not be done to our interests, ideology rules. My question is rather the manner in which this was done. I think our Lord Chairman mentioned this earlier, that we've been given this quotation from the Law Society Gazette. Now, you are the relevant practitioners. Have you had any direct refusal by the government, or has it been done by this somewhat odd way? Have other legal journals had the same?
Well,
have you had experience of similar avoidance of direct contact with you?
I can't comment on the way that the government announces what it wants to do. I can speak personally that I was called by someone from the United Kingdom Intellectual Property Office to say that this was the approach. I should say I think the UK IPO has been fantastic in all of this. They really are trying to work in the system under quite difficult conditions, not just in this area, but in other areas of IP. They're superb. And I expressed some views on that call as to whether it was right to do it in this way rather than have a formal announcement and explanation. But that's not really for me to say. My concern is not even so much ideology or non-ideology on this. It's that if one is wanting to be a self-governing nation, and a powerful self-governing nation, it is wrong to reject institutions that help you to be an independent, powerful, self-governing nation, rather than hinder. And that is my fundamental question about the rationale here. I even get people who say, well, we don't want interference. I mean, I'm quite an enthusiastic European, but I certainly get the other argument, the argument the other way. What I find much harder is people who reject the mechanisms that are at their disposal to increase their power overall. And I think that is something that is being done in this context, and I regret that.
Ms. Hamway?
I have to say, Mr. Alexander, I think you would be entirely justified in commenting on consultation or lack of and methods of announcement, but that's a matter for you. I wanted to ask about the practical implications, both for practitioners and for patent holders, would-be patent holders, those who are challenging, in other words, the commercial aspects of it. You've said that the UK has punched above its weight in its involvement so far, so what are the implications for the future in those practical ways?
Do you want to start on this?
Well, obviously the Unified Patent Court is not yet up and running, so at least to that extent we're not having to disentangle ourselves from a system that's already working. But obviously UK has played a great part in shaping how the system will work, and we had looked forward to continuing that as the court came into existence. I know that other members, other countries who are going to be members of the court, actually welcomed the UK legal expertise, because this was going to be a court that drew both on the continental civil law procedures and the UK common law procedures, so we were going to sort of have a blend, the best of both. What will happen going forward, there obviously is a matter of some speculation. At the moment, the introduction of the court has actually been held up by a challenge before the German Constitutional Court. That's been going on for some years. We have consistently heard rumours that it will be decided shortly. Those rumours seem to be gaining traction, and there is a hope that there will be a decision by the middle of this year. And assuming that Germany, that the challenge that was raised is dismissed and Germany agrees to go ahead as a member of the UPC, and I hear that there is a great will for the other members to go ahead, then if the court comes into existence, it will continue without the UK, without any UK judges, and without the UK being able to influence the jurisprudence going forward. So, although we will not be a member, UK businesses are still, of course, able to use the court, because they may have patents covering other European countries which can be litigated in that court. But it will be essentially a foreign court to us. It will be a court in which we don't have a stake, we won't have judges, we won't have any parts of the court in the UK. So it will be a different beast, I think, to what it would have been with the UK playing a very central role.
In view of the time, Lord Anderson, could you link your question 5, which is already being partly discussed, with your supplementary?
A quick supplementary first to Baroness Hanley. You were at pains, Ms Florence, to emphasise in your first answer that the European Patent Convention and the European Patent Office are nothing to do with the EU, and also that our fine patent attorneys, barristers, solicitors and so on make a big contribution to our export earnings by the work that they do before the EPO.
Indeed.
Do you anticipate that our dominance before the EPO is going to be affected in any way by non-participation in the Unified Patent Court, or can we keep those two entirely separate? And then secondly, and as Lord Chairman asks me to do, I move on to my next question for either of you. It's a hopeful question. Could any aspect of the agreement creating the Unified Patent Court be changed in order to accommodate the UK's red line as transmitted to us all last week?
Okay, well, I'll take the first one. I mean, I don't see any reason why us not participating in the Unified Patent Court should impact negatively on our participation in the EPC, because that is a granting process, and it will be the same granting process for what we have now, what we call classical European patent applications, and for what will become unitary patent applications, because the unitary effect will only take place at grant. So the whole process up to grant will be the same. The only difference then is in the enforcement. So I don't see any reason why that should, the UPC should have an effect on us practicing before the European Patent Office. And indeed, as the rules of the Unified Patent Court are presently written, any European patent attorney can represent clients with a relevant litigation certificate, can represent clients before the Unified Patent Court. Now, clearly there are European patent attorneys in countries outside the EU, and our understanding is that all of those will have rights of representation before the UPC, including European patent attorneys in the UK. So we hope that that will continue. We don't know how what will happen in the future, whether rules or procedures will be rewritten, but I can't see that an entire swathe of European patent attorneys could be cut out just like that, just because the UK has left the court. So hopefully we will. And indeed, I would also like to note that the government has recently, in fact in its negotiating objectives for the US FTA, it has said very clearly that it recognises the importance of the UK being a member of the European Patent Convention. So we very much hope that that will continue.
Now been covered in part already, but Lord Gould, you wanted to say... Sorry, my apologies.
We've had this big issue of the government being so concerned at the CJEU's continued involvement with things. Ironically, the UPC provides a model as an alternative for problems to be resolved. It's a model that we should be looking at in other ways, and yet we are turning our backs on something that's actually there to, or will be there to do exactly what we might like in resolving the issues in how one looks at European law decisions.
Makes a very good point. You might say that for those who don't like things being done through the EU and prefer things to be done internationally by convention, this agreement provides a model for that kind of cooperation, as indeed does the EPC. But if one says, well, we are not having anything to do with EU law, in circumstances where our trading partners are obliged to do so, you rule that out as a model for going forward completely. And that is the reason why I was rather critical of the reasons for rejecting this approach in this context. And I have to say, I think this applies more broadly than just the UPC. This is about the approach the government takes to its relations and its ability to make agreements with other countries. That's not for now. Just following up very briefly on the questions, one of the points that's been made was that other European countries were very much hoping that the United Kingdom would remain involved, partly because of the strength of the United Kingdom judiciary. In this area, it is absolutely phenomenal. It's regarded as one of the finest in the world, not just technically able, but also very broad thinking, because the patent lawyers don't just do patent cases, they do a range of other cases. They have brought a huge amount to this project. The rules of procedure, quite a lot of them are in a sense based on the rules that were developed by the UK for its court designed for small and medium-sized enterprises, the Intellectual Property Enterprise Court. So we've been absolutely at the heart of creating this system. And that, I think, is one of the reasons why there is so much regret in the community that it will not, the IP community, that it won't be possible to participate.
I think I'm getting the message. Does Mr. Alexander want to add to the comments regarding question 5, which already...
Will it be possible? Well, very briefly on that. So Article 20 of the UPC agreement says, the court shall apply union law in its entirety and shall respect its primacy. Now, if you have a red line that says no agreement can have that kind of thing in it, then it's quite difficult to see how you move forward. And the reason is this. The legality of an agreement of this kind also falls to be determined by reference in part to EU law. Historically, there was a challenge to an earlier version. And if an agreement says, well, actually, we're going to have absolutely nothing to do with EU law to accommodate one of the government's red lines, then it is possible that EU law may say, well, if you're making that kind of agreement, if you, the court in France, are agreeing with the United Kingdom that you won't apply EU law, wait a moment, how is that compatible with the French court's approach to being a member of the EU? And so the question has a bipartite answer. One is whether the red line remains, and the other whether if it does, to that extent, what is left in terms of the negotiating space is then doable as a matter of EU law. That is itself a complex question of EU law.
I think you've almost persuaded me that we're cutting off our noses to spite our face. I just wondered how far it goes. It crossed my mind that we or the government might be doing it as a matter of leverage to try and get something in return from Europe. But I just wondered how extensive this is. I understand that the UPC isn't yet up and running because it hasn't been ratified inter alia by Germany, so it doesn't yet exist. I'm also wondering how we cope now and in the future with the countries I'm guessing are most likely to be difficult over patents. China, Japan, USA. I mean, if this is only covering a small number, should we calm down and say, right, there's a bigger problem out there? And are there any advantages at all to us not participating? So its extent, in the overall picture, just how damaging is it? Given also stem cells. I'm interested in stem cells, and they're not covered by European law because they've got a different ideology about it.
That's a very good question. And one of the issues may be that, bearing in mind the increasing power, for example, of Chinese intellectual property administration, including actually very effective patent officers, courts, and so forth, which have ramped up recently in the last few years, it may be said that it's even more important for Europe to have the most efficient, most streamlined, easiest ways of dealing with these issues, because we're not just squabbling among ourselves. There are much bigger issues at play in this, and we ought to be putting our battles to bed and actually looking much more broadly. That's a much bigger sort of political debate. On stem cells, that's a very isolated issue, and I think it may be, if there is interest in that, following this up in writing would be useful, because there are two key cases on this. And the question there is the extent to which the approach to restricting patentability in that context actually has had an impact on R&D in this country and in Europe in general, and whether it's specifically patent issues that have that. I don't feel equipped to answer that question. It's a question of industrial economics as much as patent law, and it is certainly not clear that the decisions that have been reached by the Court of Justice in this area have had, in the long term, a major impact, partly because of where technology is in stem cells at the moment.
Sorry, just on the...
China has been breaking patent laws. Is that right?
I think
I think China has improved its intellectual property regimes as it's becoming more developed, and that is a trend that is generally seen in countries as they become more economically successful and have their own homegrown industries. Then they do tend to rely more on intellectual property for their own industries, and therefore tend to become more respectful and have stronger IP laws. So it is improving in China. There are still quite a lot of problems, and particularly on the trademark side, I think. But I think we are seeing an improvement in the Chinese patent courts.
Do Japan and the US respect European patents?
They have their own systems. So there's a US patent, a Japanese patent, granted in similar ways. The US has obviously a federal system, so it's a patent granted for the whole of the United States, administered by the USPTO, which is a little bit like the EPO, and then enforced in federal courts. In fact, in a way, the UPC system would be like the US system in terms of a federal enforcement for the whole of the European territory. Just on your point about looking broader and particularly east, in a way one might think of China as following the very traditional model. What you want to be as a developing country is sucking in technology as much as you can and being a kind of copyist. That's what the US did, that's what Switzerland did. As soon as you've got to a position where you've got your own R&D industry, you want to be a proprietor. And so, who is the biggest company filing patents in the electronic space, or telecom space at the moment? Now, it's Huawei, because China has moved from the historical position of being we want to take things in, to being someone who wants to say, now we want to protect our territory, actually. And this is why, looking at some of these issues, you need a much broader kind of geopolitical perspective, and why, on the point of cutting off one's nose to spite one's face, I think of it slightly differently. It's letting small things get in the way of a much broader picture that is important for this country's strength and independence.
Comment from colleagues? Lord Hollands, next question.
Began answering the question I was going to put, and that is, what's really behind this legal challenge in the German Constitutional Court? What's behind the what's the argument about?
The details of the challenge, as I understand it, have not actually been made public, although there's been quite a lot of speculation. I think I'm right in saying that.
There's some material on it.
Yes, there are. We believe that the case has been brought by an individual lawyer, German lawyer, but I think it may be concerned with the number of levels of appeal that are available in the UPC. So the UPC will have a court of first instance, and then there will be an appeal to a central court that would be based in Luxembourg. So that's just one level of appeal, if you like. And I think in Germany, in the German courts, they have 2 levels of appeal, and so there was some concern that the rights that you're getting to appeal in the Unified Patent Court would not be the same as you would get. You don't get as many chances as you would get in the German national courts. That's just an understanding based on what's been in blogs and some reports. As I say, we haven't seen the details of the challenge.
If I can just fill in on this and perhaps follow up in writing if that's convenient for you. As I understand it, there are, broadly speaking, 4 grounds. One of them is that the procedure for transferring the powers to the Common Court has not followed the constitutional requirements under the Grundgesetz in Germany. Another is that there is, in broad terms, a defect in the democratic requirements with respect to the legislative powers of the organs of the UPC. A third, it relates to the legitimacy and independence of the judges in the UPC. And finally, it is said that there's an incompatibility with EU law. Now, how those all relate to the specifics of German constitutional law, as you all know, German constitutional law takes a slightly different view of the relationship of its law to EU law and institutions. It's a somewhat more protective jurisdiction, is not something on which I'm specialised. And I can try and find information for you afterwards, but probably not now. Now's not the time to take up time on it.
Does the German government and German industry support strongly the agreement itself?
They do.
Yes. It's been one of the leading links.
Yes, German industry is
so is there any hope that the court will actually, overthrow the challenge and sort of bring it going?
That is very much the hope.
It's hope or expectation.
So effectively, it's a lone German lawyer against the unified voice of German industry.
You could say that. You could say that it might be a group of judges in Karlsruhe sitting in a constitutional court.
The Bundesverfassungsgericht.
In the Bundesverfassungsgericht against the judges in the German judges sitting in the Bundesgerichtshof who deal with patent matters, who are also very supportive of the Unified Patent Court. And in Germany, the balance, as I said, of constitutional powers is somewhat different. So quite where it comes out, I would hesitate to predict. The dominant view, I think, at the moment is that it's likely that the challenge will be rejected by the Constitutional Court. But as I said, I don't have expert knowledge of that.
Building on Baroness Dietsch's question, if in fact we fail to participate, how damaging, in your judgment, would that be to our inventors and to our creative industry?
Okay, well, that's quite a difficult question to answer, and again, I think merits proper economic analysis. Let me just illustrate a few areas where it may be damaging. First of all, the court is intended to improve enforcement for SMEs particularly. They're the people one wants to worry about. The big pharmaceutical companies, in some respects, they can kind of look after themselves. If you've got an $8 billion drug, then costs of enforcement and so on, they pale into insignificance. If you're an SME, that's a different question. So you're affected by inefficiencies in the legal system more than some of the big people are. So having a unified court to enforce your rights is actually really a good idea. Equally, though, if you're an SME and you're affected by someone else claiming unjustified rights in a territory, you're affected. You can think of a patent as being one of the dominant non-tariff barriers to trade. It's an absolute prohibition. So what you want is a really quick, efficient way of ensuring that either your product doesn't fall in the scope of the claims or the patent is invalid or whatever. Again, the Unified Patent Court is intended to provide that. Now, if one is the United Kingdom, for both reasons, one really wants to have influence on a court that is doing that in a territory that's adjacent territory into which one wants to trade, not just for the SMEs, but also for those servicing the SMEs. So you don't want a position where an SME says, well, I've now got to use a French lawyer or whatever to defend myself rather than using a UK lawyer to defend myself, when the whole idea was to make life simpler for the SMEs rather than more complicated. And one of the fears may be is that, as with the systems of this kind, things are kind of fine for multinationals because they sort of always are. But they're actually less fine for the people one really wants to encourage, the people where the legal costs and what might be called the legal friction is a dominant factor in their success. And that is one of the things that kind of we as lawyers concerned with the administration of justice and making it easier and fairer for people are concerned about.
And speaking as a patent attorney from industry who has been involved with multi-jurisdictional litigation in Europe, even as a large company, it is time-consuming, it's all-consuming, and quite logistically difficult to be carrying out parallel cases in Germany, in France, in the Netherlands, in Spain, as Daniel has said, with different sets of lawyers, with different procedures, different evidential requirements, different timetabling. It's very, very difficult, even for a large company. So for an SME, a complete nightmare, I imagine. So having this single court, one-stop shop, covering all of those European jurisdictions was going to aiming to really make litigation much more effective. And what we hear from inventors time after time is, well, it's cost me enough to get my patent, but I certainly can't afford to enforce it all around the world or all around Europe. So having a court that made that more likely was going to be a really good thing. And of course, people can still use the court, but without having that British flavour that would have been so useful for our industries.
Lord Gould?
I feel incredibly privileged to be part of and listening to this seminar that you've been giving this week. Do you think the government actually understands what this is all about?
Yes. Thank you. That's really important. I think the answer to that is no.
I wouldn't like to comment on the government understanding, but understanding of intellectual property issues is generally not high. I think we've had some very informed questions from the committee today, which is great. But I think there is, people just don't engage very much with intellectual property. People still talk about a world patent, which doesn't exist. So I think probably people in government don't understand all the issues to the extent that I think some of that your questions demonstrate that you do.
If I may be allowed, I'd endorse what Lord Gould has said. Lord Anderson of Swansea and then Lord Anderson of Ipswich.
I was coming to the last question.
Yeah.
No, go ahead. Basically, for me, patent law is a closed book, so I've often benefited from that seminar, but I'm just puzzled by the fact that the enforcement improvement is so obviously desirable that it has taken so long. What have been the major roadblocks on the way? And I was looking forward, where do we go from here? If we do not participate, what are the next desirable steps?
I think the creation of a unified patent court has long been, it's been a long felt want, but it has been, it's had a checkered history. I think, as Daniel said at the beginning, in a previous, initially, it was envisaged that such a court would cover all the countries of the European Patent Convention, so that it would cover EU and non-EU countries. And my understanding is that that was one of the stumbling blocks with regard to the Commission. I'm not entirely sure of all the legal arguments that went on. Some of this happened before I became involved in UPC matters. But getting agreement between a large number of countries, of course, always does take time. But since, I think, 2012, when the new the new conception of the court was being discussed, then things have progressed quite quickly.
Could I just add briefly
Daniel, you probably know more
to
than I
that? First of all, actually, one has to look at IP harmonisation against a background of nation-states being quite protective of their own patch in some ways. And everyone thinking, well, we've got the best system, how are we going to create a better system? Doing the rules of procedure for the court alone, I think they went through 18 iterations, many subcommittees and so on, to try and blend national traditions. And before we get too kind of gloomy and down about this, we have to realise what actually the UPC is. It's probably the most ambitious international court that has actually ever been created. We're trying to create an international court, multilingual, multi-locational, trying to blend legal traditions from different areas, involving a combination of specialist judges, which is actually quite hard in a specialist area, with public legitimacy, because patents are not just a narrow techie area. They require public legitimacy in order for the system to operate. It's a challenging thing to do, and it takes time for everyone to be happy about it. One of the things that the very process of trying to create the court has created is almost harmonisation. I've called it harmonisation by lunch. What I mean is this. The judges have had to get together to say, actually, we need to forge a common European thinking on this. We're going to need to work out rules of infringement and validity and so on. They have these regular conferences and meetings and so on. That has actually created an element of common thinking in this area, which has existed in parallel to creating the institutional requirements. Finally, next steps. Well, we don't know what's going to happen to the German challenge. That's the next issue. We don't know whether, if the challenge is rejected, everyone will be happy to go ahead with the system as it currently exists. There will need to be a renegotiation of the UPCA to reconstitute it in that form. That's not necessarily straightforward. Obviously, there is momentum for that at the moment, and people have indicated that they want to do that. Who knows where matters will end up? I think, to answer Baroness Hamway's question, we'll come back in a year's time to look at what the actual impacts are. It's a little bit too early to say. And could I finally say on this, first of all, to endorse the fact that for us it's a privilege being here with you, and that you should take an interest in this. One of the things that I think we find about IP as kind of enthusiasts and practitioners, that when people start to look at it, actually they say, this is kind of an interesting area. It seemed rather techie and dry and narrow, but this is about control of technology, the power of the courts, it's about the future, fundamentally. And so it's an interesting area. Is the government paying enough attention? Do they understand it? I am convinced that they can be made to understand it. I think there is an element of shallowness of thinking that says, well, we look at this, it says the EU is involved, right, we strike this out. But a discussion of this kind with reasonable people, I think, actually can make genuine progress.
Are you prepared to give a seminar to the
Look,
to the government?
I'm prepared to talk to anyone who will listen on this, to actually try and not have sort of silly things be obstacles. I'm very happy to have genuine ideological debates be obstacles. That's sensible, that's politics. But for kind of pointless things to stand in the way, I think that's just, at this stage in the country's history, that's not where we should be.
Thank you.
Lord Anderson, the position last.
May I take advantage of your presence to move away from a narrow focus on the UPC to look at intellectual property law more generally? You may or may not be aware that in the EU Withdrawal Agreement Act 2020, our parent committee, the House of Lords EU Committee, was directed to examine proposals coming out of Brussels over the course of this year that engage a vital national interest. And I'm sure our legal advisors will be trying to identify what proposals might meet that criterion, whatever they are. Is either of you aware of anything in gestation in Brussels, something that might break the surface this year, that you think could arguably engage a vital national interest and that therefore our parent committee or our successor subcommittee might want to look at? You're allowed to say no.
That might be something that we need to think about and get back to you.
I think I would also like to get back to you on this. There is obviously some discussion at the moment about SPCs.
Yeah.
That's a very important area for patents. I know it's a sort of sub-nerdy area in a way in patents, but it's a very important one. And that is under discussion at the moment. One of the things about intellectual property law, though, in Europe, is that there has been a very extensive programme of harmonisation already over the last 20 or 30 years. And a great deal of that has involved essentially, with some changes, other countries adopting quite a lot of what we want to do ourselves. So it hasn't been a difficult process of harmonisation in many areas. If one thinks about, there are specific areas, for example, in the Copyright Directive, where there are reasonable differences. But overall, it's been quite a successful process. So I think what we ought to do on that is probably revert to you on general matters of intellectual property which are under examination. And also I would say that intellectual property law doesn't exist in isolation. It exists in cooperation with regulatory law in some areas, in competition law and so forth. So there are other areas of EU law that touch on this subject, where the interrelationship between those areas of law can be as important as the substance of any proposed changes to the specific domain of intellectual property. So if you would permit us to think about this and, if appropriate, write to you, Mr. Chairman, then we'd be happy to do that.
Is there any other issue that you would like to raise that we have not explored? We've gone over the ground quite a few times, and this has been highly educational. It has been a seminar, as Lord Cole said, dealing with practical issues which have been put into the front of our minds as against ideological decisions. Is there anything you want to add?
Not so much add, but if I may just revert to a couple of points that I just wanted to add to what Daniel had said earlier, if that's okay. And just very briefly, so one of the questions related to the way the announcement was made, and Daniel mentioned that he'd had a call, and indeed the head of the UK Patent Office, Tim Moss, did call all the heads of the key IP organisations in the UK. So we did get personal contact and have the news personally from the head of the UK IPO. So that was something, that was helpful. But I agree that the fact that there was no general announcement did seem rather strange to us. The other aspect that I wanted just to revert to was on question 5 about whether any aspect of the agreement could be changed in order to accommodate the UK's departure from the EU. And I think there are 2 points there. I think there's a distinction between what could be done in the face of departure from the EU and then what could be done in the face of the red lines. And I think if there were no red lines, it would have been so much easier to accommodate the UK still remaining a part of the Unified Patent Court. And I think it's important that we recognise that, because it's very much hoped that in future that court could be expanded to include other European countries that are not members of the EU. So I think it's important to recognise it's not simply the fact of us leaving, but it's the fact of the red lines. Those are the 2 additional points that I wanted to make.
Any comment from any of our colleagues? But thank you very much, both of you, for your most valuable session at a most opportune moment, given the announcement. Thank you very much indeed, both of you.
And thank you for your questions.
Thank you very much for your questions and attention to this issue. I hope you'll, as it were, keep an eye on this area generally.